Based on my 25 years experience and the nearly 100 bid protests that I have filed, I'm going to talk to you about the 5 most important things you need to know about bid protests. Before we get there, what is a bid protest? A bid protest is nothing more than a challenge filed by a government contractor who has submitted a bid or a proposal in response to a IFB, an invitation for bids, or a solicitation, but hasn't won award of the contract. The bid protest challenges the agency's conduct of the procurement or the agency's decision to award the contract to its competitor. All right, the 5 things you need to know. The first and the most important thing you need to know about bid protests is timing. I'm going to throw 3 numbers at you, 10, 5, and 3. A protest must be filed within 10 calendar days of when the protester knew or should have known the grounds for the protest. However, if the protester wants to stop the contract award, another time frame is applicable, 5 calendar days. In order to suspend contract performance, a protester must file the protest within 5 calendar days after it receives a debriefing from the agency where a debriefing is required by regulation. A debriefing is required by regulation generally under negotiated procurements conducted in accordance with FAR Part 15. Under FAR Part 15, the agency must give a disappointed offeror a debriefing if that disappointed offeror requests a debriefing in writing and within 3 calendar days after receiving notice of the award. The second most important thing about bid protests is where to file the bid protest. There are 3 forums in which a protest can be filed. At the agency itself that conducted the procurement, at the Government Accountability Office, also known as GAO, which is an arm of Congress, or at the U.S. Court of Federal Claims. The differences among those forums are primarily likelihood of success and cost. All right, another important thing you need to know about bid protests is what kind of relief are you going to get if you win? Many people believe that if you file a protest and win, you're going to get the contract award. Unfortunately, that's not true. The agency ultimately stuck with the contract, so these forums are not likely to substitute their judgment for the judgment of the agency. The best that you can get is an order or a recommendation that the agency go back and correct its mistakes that it did during the procurement. For example, reevaluating your proposal or the competitor's proposal or reopening discussions. So you might be able to get a second bite at the apple, but you're not likely to get the contract award. The 4th most important thing about bid protests is, do you need an attorney? Well, that depends. If you're filing at the agency level, that typically only requires filing a letter setting forth the grounds of the protest. So you can do that yourself. Of course, if you use an attorney, they might be able to advocate better on your behalf, given the knowledge they have about grounds for protests and what's normal and what's not in the conduct of a procurement. If you're filing at GAO or the U.S. Court of Federal Claims, I think you're going to need an attorney. Why? Well, in those 2 forums, there's a more intensive process, and in particular, the agency will disclose a proposal if the allegations address the evaluation of either your proposal or competitor's proposal. Obviously, you don't want your proprietary information disclosed to maybe the counsel that's representing the competitor, and they likewise don't want their information disclosed to you. So in those instances, the forum will institute something called a protective order, and individuals admitted under the protective order can see the information. Attorneys representing clients can gain admission under the protective order if they file a declaration that they are not involved in the competitive decision-making of their client, and if they promise not to disclose the information, proprietary information, to their client. So I think it's best to get an attorney in those instances, because otherwise you're not going to have a discriminating review of the record. The last and most important thing about bid protests that you're likely want to know is, what do they cost? Well, most attorneys charge by the hour, so the rates that they charge is important. And most attorneys will tell you that the cost associated with filing a bid protest and pursuing that protest has to do with the complexity of the procurement, the complexity of the issues raised in the protest, and maybe the size of the procurement. If you were to ask me to file an agency level protest, that's likely not to cost more than $3,000 to $5,000. If you were going to ask me about filing a protest at the GAO, in my experience, filing the protest and pursuing the protest, if it's a simple, straightforward protest, costs about $20,000 to $25,000. The U.S. Court of Federal Claims is by far the most expensive forum, and to actually get into the court, because of the formality and the significant procedures involved, filing that protest will cost as much as $10,000 to $15,000. Pursuing that protest is far more expensive because the court may allow you to have hearings, may have conferences, and may require several rounds of briefings. So the cost associated with the protest at the U.S. Court of Federal Claims can escalate to over $50,000. Will other attorneys do it for you cheaper? Sure. But remember, you get what you pay for.